Ladies and gentlemen, I welcome all to my channel. Supposing a check bouncing case is filed as against you, or supposing a person is threatening you as if he is going to file a check bouncing case, how do you deal the situation? What are the steps you have to take? How to handle this issue? Are all discussed in this video. As far as the check bouncing case is concerned, it is an offence under Section 138 of the Negotiable Instrument Act. So, supposing a check is bounced, for which and the procedures stipulated under Section 138 of Negotiable Instrument Act is followed, then the court may impose impose a punishment in which the court can issue a order for a fine, or the court may order for an imprisonment up to 1 year, or court may also order both. So that is it's a stipulate it's a punishment. 138 check bouncing is an offence punishable under Section 138 of the Negotiable Instrument Act. Normally, when a person receives a loan, whether it may be a housing loan or it's a vehicle loan, or if you go for an urgency, the lender will ask you to give you some checks, blank checks with signature, or with sometimes they will ask a filled check with signature as a security for the repayment of the loan. So, sometimes when you are purchasing the property, suppose you are purchasing some materials, that time also the seller may insist you to give you a check as a security for the delivery of the material. In that case also, when the check is in the hands of the seller, he may also threaten you to file a criminal case, or he may also file a criminal case as against you. So as far as the threat is concerned, whenever a person who holds the checks threatens to file a criminal case, threaten to present the check in the court, the bank, and to file a case, it is always better to compromise the issue. You should try your level best to compromise the to make a compromise. Supposing he was saying that I am going to present the check, you can tell the holder of the check to give necessary time, or you can make some alternative arrangement. You may say, I do not have this much of money, I will give you the money in installment. Like that, you can explain your difficulties, and you can also explain your problem, and you can also try to reach an amicable settlement. As an abundant caution, it is always better to avoid issuing any checks. Normally, in several cases, the husband is doing business, and they are doing the business in the name of their wife, in the name of his wife, and sometimes they issue the wife's checks, and the check is ultimately they are not in a position to honor the check. Then the holder of the check files a criminal case as against the wife, for which the wives were constrained to appear before the court for each and every hearings. So they are facing unnecessary trouble, hardship in the court. From that, the husband and wife fight came out. Then it became such type of dispute, misunderstanding between the husband and wife go up to the level of divorce. So whenever when you are doing a business in the name of your wife, it is always better to avoid issuing any checks in the name of wife, because if the case is filed as a male, you can go to the court and you can handle the issue, and you can comparing with your wife, you may be in a comfortable position to go to the court, or to handle the issue. But if a check is issued in the name of your wife, and the criminal case is filed in your wife's name, then it will be a difficult job to your wife, and you will be find it very difficult to handle the situation. So you being the wife, supposing you are a woman and your husband is doing a business, and he was asking you to issue the check. So in that case, it is not advisable. It is advisable to see whether sufficient funds are available in the bank. You being a wife, you should not blindly say, put your signature in all the check leaves. If you put a signature in the check leaves, criminal case supposing the funds are not there, there's a chance for the holder to file a criminal case. In that case, you will be got in trouble, and you will have to unnecessarily face all the criminal cases, and you will have to go to the court. These things will happen. So if you are a wife or if you are a ladies, you should not put your signature in all the checks blindly, and you should be very careful, and you should take utmost care and caution before making any signature in the checks. And you should know that the consequences of the check dishonor and as it amounts to an offence punishable under section 138 of the Negotiable Instrument Act. So normally, suppose you are a man also, in that case also, we should be very careful, and you should avoid issuing a check. If you do not have any fund, you should try your level best in issuing any checks. Without any fund, you should not issue a check. If you have a fund, it's okay. If you don't have a fund, it is better to avoid issuing any such checks. Normally, what happens when you are in distress position, when the people are in urgent need of money for the payment of school fees or hospital expenses or medical expenses or for any other urgency, whenever they approach the financier, they put they put the signature in all the blank papers, and they also issue blank checks. And sometimes some of the financiers are misusing the distress situation. Sometimes they give a check, they give a loan for 1 lakh, and they get a blank check amount, blank signed paper with which they create a document as if they have given a 10 lakhs loan or different amount, and they threaten to file a big case. They have threatened to file a case for a higher amount, and they are also filing cases. In several cases, we see that the financiers are receiving kanduvati, metervati, and high level 5%, 10% interest rate like that. They are charging, and they are on that ground also on that rate they are filling that amount in the blank papers, and they are filing the cases. So whenever you are receiving a loan, it is always better. You should write the proper loan document. In the loan document, you should properly mention the amount, check amount. Even if you are issuing a check, you should mention. You should write down. You should mention the. You should fill the amount and the draw's name, so that you can confine that situation. Sometimes what happens, you are issuing a check to one person, blank checks, and you are also signing some papers in a blank manner, and they are handing over that paper to another person, and they are trying to file a case on the basis of the blank papers, and they are creating a document, they are making a document, and they are filing the cases. So in all cases, to avoid all these things, it is always better to avoid issuing a check. If you are constrained to give a check, it is always better to fill the check and fill the amount and fill all the details recorded in the check, and you can issue the check, so that you can restrict the risk possibilities. So once the case is filed, then how to handle the case? So nowadays, the latest judgment of the Madras High Court, which is pronounced by Lordship Justice Anand Venkatesh in February 2025, it was mentioned that these cases has to be conducted in a summary manner. Even the previous judgments of the Supreme Court also stipulates that all the check bouncing has to be tried like a summary case. So what is summary cases? When a person is conducting a nuisance, or supposing a person fights in the street. So that type of cases are conducted in a summary manner. The judge will, in such cases, judge will simply ask whether you have done a mistake, or whenever you have fight in the road, or when you committed a nuisance. Then yes, when the accused say yes, then automatically the judge will pass a judgment on the same time itself. So now the courts are, now the trend is going in such a way that these check bouncing cases should also be tried in such a manner. So when a check bouncing case is filed and notice, you receive a notice or a summons from the court, then you will have to file a petition before the court. In that case also, you can first of all, if it is possible, you can offer the court, I am ready to go for settlement, I am ready to settle the case out of the, I am ready to pay the amount. So in that case, the court will refer the matter to Lok Adalat. There you can negotiate with the party and you can get a time, and you can, if you suppose you are in a position to return the money, you can ask the time, and you can, in installment, you can make a payment, and that type of agreed arrangement may be recorded in the mediation center, and on that basis you can settle the amount in installment during the agreed period. Supposing you do not have the holder of the check is not prepared to come forward, is not prepared for a amicable settlement, then in that case you will have to file a petition before the court saying that supposing if the check is also filed for higher amount or any fraud is committed, then you can file a petition before the court saying that I have a good defense, it's a fraud, they have by fraud they have collected the check and they are trying to misuse the situation. Like that, you can file a petition and you can ask the court to convert the summary proceedings into a summons case proceedings. So in that case, if the court will convince about your defense, then the court will not try the case in a summarily. Then the court will conduct a detailed proceedings, detailed inquiry, and then in that the detailed inquiry is conducted, then you can get a time at least for 3 to 1 or 2 years time. The court, the detailed inquiry will take 1 or 2 years period to conduct a detailed inquiry in the case. In that case also you can get a time, and in that you can also you can prove your defense, and you can take several defenses which are available to the accused, which were already discussed in my previous video, that you can see in my previous video. In the meantime also, if it is possible to you, you can go for an amicable, you can raise funds and you can try to settle the amount and close the case. Once, supposing if you fail to prove your defense, then the court may pass a judgment, and in the case there's a possibility to the court may impose imprisonment, and the court may also impose some fine, against which you can prefer an appeal to the district court, and again you can go to high court to the second appeal. So during the appeal also, you can if you have funds, you can raise the funds and you can settle the amount. That is it is permissible under law. So as far as check bouncing case is concerned, it is a quasi criminal case. It is partly civil, partly criminal. So it is called as quasi criminal. So you can settle the case in the magistrate court itself, or you can settle the case in the district court itself, or you can settle the case in the high court. So at any stage you can go for a settlement, if provided the other party is ready to, the complainant is ready to accept the settlement. Even otherwise, you can offer the settlement in the court of law, and from the court you can ask the court to refer the matter to Lok Adalat or mediation center. So from that also you can settle the case. In cases it is not possible, then you have to, if you have good defenses, you can conduct the case, which those defenses were discussed in my parallel video. In some cases, what they are now, suppose the parties are not in a position to pay advocate fees, or suppose they are not in a position to conduct the case, or they do not have any means. What they are not, they are absconding. They are absconding for 2-3 years. In that case, the courts are insisting the complainant to procure the accused through police or through other ways. Supposing the accused, the complainant is not able to trace out the accused, suppose the complainant is not able to find out the address of the accused or whereabouts the accused, in that case the court will wait for some time, and the court will give reasonable opportunity to the complainant to take necessary steps to procure the accused. In several cases, in several cases, the people who do not have money are simply absconding, and then the case is pending for 2 to 3 years. Ultimately, the courts dismiss the case due to the non-prosecution on the part of the complainant. These are the things happening in the court. So I am not advising you to go and abscond, but it is the fact, it is the things happening in the court. So, as far as the complaint is concerned, if the parties are in a position to pay the amount, it is better to go for a settlement. If the parties are not in a position, you can at least you can consider those the financial position of the accused, and it is always better to reach an amicable settlement. That will be a good idea. Win-win situation will be created. Or otherwise, if they are harassing the people for in all possible manners, and if the accused are not in a position to pay the amount, or they do not have any livelihood, in that case they are simply absconding. In such cases, you will be then it will be a loss not only to you the complainant, it will also be a what is it will be a it will also cause a uncomfortable situation and a lifelessness situation to the accused. So that is not a desirable thing as far as the check bouncing case is concerned. So as far as the check bouncing case is concerned, it was incorporated with a view to help the complainant to recover their money easily if it is so possible. So even if the accused are in a position to pay, or if they have financial capability, it is always better to insist the party to pay the amount. If it is not possible, then it is always better to give them a time, reasonable time, so that they will also come up in the life and try to settle the amount. Or otherwise, it will be a loss both to the complainant and to the accused because of these unforeseen circumstances. So these are the legal position with respect to check bouncing case. So as far as the check bouncing case is concerned, it is always better to avoid issuing any check. If you have per hand, you issue a check. Then you try to make the payment in time, and you to honor the check as much as possible. If it is not possible, try to negotiate with the complainant as much as possible and settle the case before filing the case, or even during the case you try to go for amicable settlement. That will be a good idea. And if you have good defense, you can engage a lawyer and conduct the case, and if you can try to prove your case. This is the thing I wish to give you through this video. Ladies and gentlemen, we have two channels. Razyak Sattamarivom is a English channel. Razyak Sattamar is a Tamil channel. Razyak LawTube is an English channel. Through these two channels, you can have view so many videos and enrich your legal knowledge. If you have any doubt with respect to any subjects, any branch of law, any issues, legal issues, you can watch my channel, and from the channels you can find out a playlist. From that you can choose a relevant video and clear your doubts. In addition to that, if you have any specific doubts, you can also contact me to the cell number. If time so permits, I will give you reasonable consultation through phone or through in person, depending on my time and availability. I will come again with another topic. Until then, goodbye. It's Razia Ali.